No, I didn't just decide to stream today so I could see my new opening, though. That's kind of a reason too. Actually, what I wanted to do was quickly get some thoughts down on John Waters. I did my first video on natural law just before he started a three-part series on natural law, which is quite interesting. I have nothing to say bad about it. It is really excellent. Um, but it did raise a couple of interesting issues that flowed from my two videos and my two Substack pieces on natural law that I thought I just want to get down before I lose the train of thought. These are really good articles. He provides a lot of analysis with examples from the Irish Constitution and case law. I'm not going into any of that. What I want to do is touch on two things that arise from his three-part series, mainly the first two. One is, talks a lot about fundamental rights and human rights. And what really jumped out at me is the question, are fundamental rights and human rights, are they really natural law? They have anything to do with natural law, actually. The other question that arises from especially the first two bits from his series are, what happens when you put inalienable rights, fundamental rights, into a written constitution? What happens to them in the modern world with a modern judiciary soaked in positive law? Why did, and you'll see that in his articles, why, and that they're all on Substack, why did the Bill of Rights, the Charter, conventions, and constitutions fail to protect the inalienable rights they ostensibly were designed to protect? Why was that? So let's just start by looking at his first article. All right, here we go. The natural law tradition has for centuries been the guiding light of Western civilization, but human cleverility, that's a great word, has recently conspired to jettison it because it is said to offend against modernity. That's Aristotle here. There has, it seems indisputable, been a dearth of discussion of a particular aspect of the mass overnight defenestration of fundamental rights by Western governments in the spring of 2020. This relates to the basis on which the suspensions of constitutions and the abrogation of rights, conventions, and charters could have been effected, given that many of the affected rights were, in the relevant documents, characterized as, if not totally absolute, then certainly more robust than a minor respiratory ailment ought to have been capable of striking down. The language of many of the affirmations and guarantees of these rights, with their use of words like inalienable, indefeasible, antecedent, and imprescriptible, is such as to suggest them as capable of withstanding more than an unsubstantiated declaration of a global pandemic by an unelected supranational body. Moreover, one might have expected that even if the courts systems of the various affected jurisdictions were not themselves in a position to unilaterally intervene in order to carry out their primary function of protecting such rights, and by extension the conventions, charters, and constitutions, they would, at the very least, have been moved to expedite and support any action by a citizen seeking to have the legality of these abrogations scrutinized, and, if found wanting for justice, struck down as unlawful and earmarked for watchfulness as to the possibility of repetition. The contrary tended to occur. Wherever actions were initiated, especially in cases taken at an early stage and seeking a wide-ranging examination of the rights abrogations involved, applicants found themselves subjected to a circular form of judicial reasoning on the preferred basis that, since there was, in train, a deadly pandemic, governments were justified in whatever steps they might have taken. Universally, in all but a tiny minority of cases, attempts to have the COVID measures subjected to judicial review were rejected out of hand, with only cases involving peripheral issues of personal grievance seeming to attract the sympathy of alleged judicial watchdogs of human freedoms. And he first asks, is this just because judges are political appointees in Canada, where you literally have to file an application, submit your social media accounts for scrutiny? That is undoubtedly the case. But then he goes on. That's not the only reason. But there is a deeper factor, which has to do with the antecedent underpinnings of fundamental human rights and freedoms as expressed in constitutions, charters, conventions, and bills of rights. The long-time understanding in Western civilization has been that these rights are not man-made in the sense of having evolved purely from the unaided genius of humanity. So what is Waters identifying here? What I think we need to ask is, are these so-called fundamental rights, have they not always been the tools of abuse, shielding state interests and then crushing state opponents? If they do seem to be working, is it because they're in a constitution? Or is it because they are consistent with a common underlying morality? Ireland, for example, and Waters really gets into this in a lot of his analysis. He describes sort of the organic nature of Ireland and the organic nature of these rights. But in Ireland, for example, did it need a right to life in a written constitution, a guarantee of, for there to be an operating right to life in a Catholic Ireland? And the answer is obviously no. And in a pluralistic society, is any written guarantee of any help at all? And it doesn't seem to be the case. Is it because our judges are political appointees? No, it is actually a deeper issue. I think this is what we get from the John Waters 3 articles. And really, it's the data he provides, because he never quite puts his finger on the answer. When natural law was accepted as a real thing, when people really believed in it, and they did for thousands of years, there were laws that were assumed not to be man-made. And if there are laws that are not man-made, these are laws that are not subject to human interference. And that, in a way, is a bulwark against tyranny, which kind of goes against, again, this often happens in modernity. There's a kind of inversion. But if you believe in natural law, there's actually a limit to what a tyrant can do. So let's go on here in the article. So I'm thinking the fundamental rights he's talking about don't have anything to do with natural law. Many of the freedoms we have enjoyed in Western civilization have been bequeathed us in a language and logic that belong to transcendent concepts of reality, by a history in which religion was not a separate element of culture, but the very portal through which humanity looked in order to divine the meanings of reality. In a book called The End of the Modern World by Roman Gardini, he wrote that the Middle Ages were filled with a sense of religion that was as deep as it was rich, as strong as it was delicate, as firm in its grasp of principles as it was original and fertile in their concrete expression. Religious thought was concerned with the good, the good of humankind divined from observation, experience, trial, and error. Customs and laws evolved to venerate and maintain the understandings that were found to optimize human peace and happiness. In this formulation, it becomes clear that what we speak of are not especially religious understandings, but ones that belong at the center of the public square, including the public square of modern society. Contrary to the prejudices of the moment, the characteristics that distinguished the era Gardini was writing of from the mid 20th century of his writing, or indeed the present time, was not its backwardness or obscurantism, but the fact that its normative viewfinder, incorporating capacities directed at both the religious and secular realities, was capable of taking in theory and principle, the whole of reality, and was therefore far better equipped to comprehend the human structure that the thought systems and ideologies of the supposedly modern societies of the present. By embracing both science and the mysterious, the known and the unknowable, the devices of apprehension and use at that time were far less limiting of human self-understanding than the hyper-communicative technologies of 2023. And precisely because they placed no boundaries between the religious and the real, the secular and the sacred, the holy and the profane. And one thing to point out here, natural law believes that you can have metaphysical knowledge. And in my last article, I talked about the difference between starting with God or starting with man. A better way of putting it, and Waters does it here, and also George Grant does, and I'll do that in the next stream. It's belief that the metaphysical is something you can know. The positivists and the power types, CRT and all that, don't have a concept of the metaphysical. They're skeptics. So what allowed 2020 to happen? This is my view on it. And what continues to sustain the centralizing of power in the hands of a few is the rejection of natural law and its replacement by positive law, which is to say the law is what the state tells you it is. Natural law has been written off as old-fashioned and is associated with religious prejudice, but it was once a bedrock of the legal system. If there is a fundamental error in Waters' papers in his series, it is that he assumes, in quotes, fundamental human rights that emerge with Locke and Rousseau are the same thing as natural law. That Locke and Rousseau are talking about the same thing as Cicero or Aquinas. They're not. This is a mistake. You don't have any mention of fundamental rights or human rights in Cicero or Aquinas. Cicero doesn't talk about your right to freedom of speech. He just has it by his status. And that's what makes a good polis, a good society. You can talk about stuff and you have a right to talk about stuff and try to find the truth. There's no like absolute right to free speech. The fundamental rights and human rights that are bandied about now and that Waters really assumes are natural law are really emerge as natural law is on its last legs in the 18th and 19th centuries as it's falling out of favor. These fundamental rights that we have in our constitutions mimic some characteristics of natural law, but represent dangerous overgeneralizations. They're not rigorous. They don't involve practical reasoning. You immediately see exceptions, and that is a good indicator that there's a problem. As soon as the Bill of Rights is passed in the US, you immediately have Oliver Wendell Holmes saying, well, You can't yell fire in a crowded theater. Ooh, exceptions. In Canada, you have these fundamental rights finally put into a constitution, although we did have an implied Bill of Rights without any charter. That's for another day. And immediately, you have the Lord's Day Act struck down, which allowed people a day of rest. So now workers can work 7 days a week. Wonderful. Thank you, Charter. Then you see these gross overgeneralizations of rights used as excuses to allow friends of the government to run riot. Meanwhile, enemies of the government are rounded up and locked up, notwithstanding these fundamental rights. And you see this over and over. France has its Declaration of the Rights of Man, and within literally a blink of an eye, you have 10,000s of people going to the guillotine. Is that a coincidence? Let's move on. This term natural law is used to sum up a body of ethical imperatives said to be inherent in human beings and discoverable by human reason. It therefore differs from statute law and common law, although much of the latter derives from natural law, and even from supernaturally revealed divine law. Natural law is actually at its root a philosophical rather than a theological construct. That's true, but look at Aquinas and his. I mean, I don't want to quibble, but you really have to look at Aquinas here. You have eternal law, timeless law that applies to the whole community of the universe. Then you have lex divina, divine law, law revealed by scripture. You can only get it by revelation. Then you have natural law, lex naturalis, that part of the eternal law governing rational behavior and free will that is discoverable by reason. Then you have human law, like what side of the road you drive on. Okay, so just to clarify that point, natural law isn't like all from God. It's not a dictate from God necessarily. It asserts that universally human beings share a set of ethical norms, not so much based on revealed truth, although that's part of it, as the truth written on the human heart, amounting to a body of binding norms rooted in shared natural understandings as to the structure and mode of propulsion of mankind and the correct manners of behavior congruent with this. Yes, it's written on our hearts. It's written, if you believe in natural law, you believe your reason is actually a real tool to connect to right and wrong and the law. In Written on the Heart in 1998, his 1998 book about the origins and nature of natural law, the American philosopher and theologian can't pronounce it, traces the theory of natural law back to its original sources, including Aristotle, Thomas Aquinas, and gulp, John Locke. This is what I have a problem with this. In fact, there's a good case to be made that Locke is really the root of woke, in the sense of the tabula rasa, its conception of the self, the individual. So I do not agree with that. That's for another day. Moving on. In his 2011 book, Natural Law and Natural Rights, John Finnis elaborates that a theory of natural law claims to be able to identify conditions and principles of practical right-mindedness, of good and proper order among persons, etc., etc. Finnis is really interesting. I cover that in my last article on Substack and my last video. Finnis it's hard to define him. He's kind of a Thomist following Aquinas, but he's really a secularist, and he doesn't believe you need to begin with God, that reason actually operates independently. God's a possibility, is not necessary. This is the rigor of natural law that's really interesting, because he identifies a bunch of goods and then a methodology that we can apply to actually find right and wrong. So, good to read some more about Finnis. The principles of natural law, Finnis insists, hold good just as the mathematical principles of counting hold good. That's very much Finnis. This idea is shared by many natural law philosophers and thinkers. In his 2005 book, What We Can't Not Know, J. again, I'm not going to even try to pronounce it, offers the following definition of the logic of natural law. In quotes, however rude it may be these days to say so, there are many moral truths that we all really know. Truths which a normal person is unable not to know. They are a universal possession, an emblem of rational mind, an heirloom of the family of man. Yet, he writes, our common moral knowledge is as real as arithmetic, and probably just as plain. The objections raised to natural law concept and tradition through time have been varied, but have nevertheless been converging around a particular concept of power. That's a key word. Natural law it accepts that you have metaphysical knowledge. Opposite natural law are almost all other legal theories, which almost all of them, I think, and I'll think about this some more, are power-oriented. The most commonplace is that the natural law is ipso facto sectarian, or at least offensive to pluralism, because it appears to be, first and foremost, a creature of religion. There's a chicken and egg problem here, which is natural law offensive to pluralism, or does pluralism prevent the common moral community traditions you need to access common law? Interesting question. I'm tending to think the latter. One of the early objectors to natural law theory was the late 19th century English philosopher John Stuart Mill, himself an atheist. Mill's objection was essentially that principles of natural law, being framed as abstract doctrines of morality, were too vague and generalized to be of use in framing particularized laws directed at specific individuals and concrete situations. It was true that natural law rights and freedoms tended to be expressed as principles, but this was precisely their great strength and virtue, to allow the general to be particularized on the basis of non-negotiable premises. Again, the premises at work in natural law reasoning, that's one thing. Vast, overgeneralized principles like freedom of assembly, freedom of speech is something else. Thus, the early attacks on natural law arose in the context of purported attempts by power establishments to get the clerics out of people's bedrooms. Opposition to religious influence has been one of the chief avenues of attack on Western civilization by cultural Marxists. I don't really like that term. I think wokeism is not Marxism. It's something else and much scarier. Really, I think wokeism is Locke, liberalism at its really ugly end, very closely aligned to capitalism, whose proponents sought to rebuild the entire edifice of human rights from the beginning, forging power for themselves and their sponsors by representing and elevating the underdogs of history who were to be furnished with new and competing rights, which in turn could be weaponized to gain power over systems and territories. Very interesting that he refers to the underdogs of history as definitely a wokist methodology. You've given up on the working class. They're not useful. They're sellouts. You're going to use other groups as your tools for advancing your agenda, which isn't necessarily class struggle anymore. It's simply replacing the current managers with a new set of managers, namely yourself. There are not too many wokists these days who aren't filthy rich. In 1937, for example, a new Irish constitution, still in operation today, was deeply embedded in natural law, in particular in respect of fundamental and personal rights, set out in Article 40 to 44. Now we're entering into my second topic, which is what happens when you take so-called natural rights, so-called immutable rights, and you write them down and put them in a constitution. What happens? My thesis is they become positive law, human laws, and human laws can be changed. In the post-World War II period, the emerging universal trend, purportedly in pursuit of unity and non-confrontation, was to seek a lowest common denominator, pluralism. Here we have that word again. between different traditions and cultures, which resulted in a changed attitude to natural law philosophy that increasingly bemoaned the influence of revelation and theology, leading inexorably to the dismantling of the structure of bedrock principles that underpinned our legal systems, our democracies, and our free societies. Again, I don't think pluralism really cared about revelation and theology. Pluralism makes it impossible to understand natural law. You become very focused on power relations, much like a border town simplifies things and simplifies language, simplifies everything down to power and money. And that's what pluralism tends to do. Sorry. Here's some Irish stuff. Again, no disrespect to Ireland, but I don't want to get too much into the particulars. But read his articles; they're amazing. In the referendums of 2012, children's rights referendum, and 2018 marriage referendum, a few of us fighting to defend the Constitution divined that, above and beyond the instant issues being pursued, we were witnessing strategic attacks on the fundamental rights of families in a manner that was actually unlawful, unconstitutional, and profoundly dangerous. Waters is right. If you read the Constitution, it is as he says in his article. It says they're immutable. How can you amend them? The rights inherent in Article 40 to 44 include the right to life, equality before the law, reputation, property, to the inviolability of one's home, to practice one's religion, to habeas corpus procedures, to freedom of expression, to public assembly, to form associations and unions, to the protection of family life, to education, and also a number of enumerated rights, including the right to bodily integrity and recognition of the dignity of the person, the right to earn a livelihood, to privacy, to communicate, to have access to justice and fair procedures, to travel within and outside the state, and potentially many others as yet unidentified. All of these rights derive from the natural law tradition and should rightly be regarded and treated as the inalienable possessions of the Irish people, whether we had a constitution or not. I think that, I like what he's saying generally here, but I don't think all of these are necessarily from the natural law tradition. They're among the class of these overgeneralized rights, which derive from the Enlightenment. They're really nice to talk about. They don't actually work. As I wrote in another article recently, that caretaker government had no authority to concoct the package of legislation produced to deal with the claimed COVID emergency without firstly persuading the people to modify Article 28.3.3. in accordance with this characterization of the situation requiring this change. This gets into a slightly other issue, which is the power in political situations to simply override the law or ignore them, or recharacterize, redefine written constitutions out of existence, when the powers that be, supported by, let's just call it the majority, have no problem with it. The question then arises, I like this question. It's a good question. Question then arises, what then does the Constitution of Ireland forbid, protect, prevent, or restrict if such previously understood fundamental rights and freedoms of Irish citizens as had been suspended in the COVID crisis could be so suspended without recourse to the sole provision in the Constitution allowing for the declaration of a state of emergency? And this gets into the particulars of the Constitution, but the issue is, how did they do this? What's the point having a Constitution when these rights can be simply overridden in precisely the situation where they should be rise to the surface and say, no, you can't do that? In fact, what has happened in all Western countries is all these fundamental rights, fundamental in quotes, in constitutions have been simply swept aside without much ado. What was the difference between this constitution and no constitution? Exactly. The desire of establishments to dispose of these absolute rights is the true terrain of the recent Irish battles to prevent the piecemeal erosion of the fundamental and personal rights sections of the Irish Constitution. In the referendums of 2012 and 2015, a few of us divined a plundering of the fundamental rights of families in a manner that was actually illegal, unconstitutional, profoundly dangerous. And to conclude this first essay, allowing men dominion over the rights of men has long been recognized as the first step on the road to despotism. And the sole effective mechanism that man has discovered to avoid this is to acknowledge the source of these rights as residing in the hands of God, i.e., as defined in the Irish Constitution as the Holy Trinity. If this is a sectarian presumption, then it seems an essential and non-supplantable one. I have several times issued this challenge to secular atheists. If you can outline an equal or better mechanism for achieving the same thing, I will support you all the way in seeking to alter the Irish Constitution for a modern secular republic. We shall return to this question in a subsequent article. All right. So we have here, I think, exposed really the first two issues are fundamental rights. Fundamental rights, really. Do they have anything to do with natural law? Or is natural law something else entirely? Far more fundamental, far more organic, far more likely to protect you from tyranny. What happens when you put them in a written constitution in his second article is really good, not for its so much for its conclusions, but for outlining the disaster that occurs when rights that are supposedly protected in written constitution meet the modern lawyer class of positivists raised in modernist law schools, faced with arguing cases before modernist positivist judges, pro-state judges. What happens? Well, what happens is you have no rights. And I'll just highlight some of his, this is really about his experience dealing with lawyers. In advance of the 2018 governmental assault by referendum on the rights of the unborn child is recognized in the Irish Constitution under Article 40.3.3, I spent several months in cooperation with some friends and colleagues attempting to persuade various lawyers that we should mount a challenge to the government's proposal to repeal the Eighth Amendment, this being the popular name for that article, on the grounds that such proposal was illicit, iniquitous. I have to say Waters is a great writer. Illicit, iniquitous, and attack on the most fundamental rights of a category of human being. Our argument was that the rights bundled up in Article 40.3.3 were natural rights that existed not by gift of the electorate, nor at the whim of the government, nor by permission of judges, but were untouchable rights incapable of being taken away or diluted because they were in the language of the Constitution. This is actually in the Irish Constitution. Natural, imprescriptible, antecedent to, and superior to all positive law. Now you think those rights are going to be hard to repeal. Nope. Here's their experience when they meet the lawyer class. All the lawyers gave us more or less similar responses. The anterior, inalienable, etc. nature of the rights in Article 40.3.3 did indeed, on paper, one of them said, seem to render questionable the very idea of a referendum. But that was something that would ultimately depend on a view and interpretation to be taken by the courts, which might find, as the Supreme Court had once before in a 1995 case, that the Constitution is the source of all Irish law. Okay, bingo. The Constitution is the source of law, man-made law. And the people have a right to amend it in whatever manner they see fit. The problem, they explained, was that concepts like inalienable and imprescriptible derived from natural law, a concept that was rapidly going out of fashion. There's a chuckle among lawyers when you talk about things like principles that are above practicality. Lawyers will actually laugh, chuckle. The judicial climate of the age, they said, favored positive and procedural law far more than in the past, and looked askance at the idea of absolute law, whether labeled as divine law or natural law, somewhat, though not wholly the same thing. Concepts now regarded as weak, precisely because they propose concepts of entitlement outside the gift of human agency. So really the age of positive law. What the state says is the law, provided proper procedures are followed. All the lawyers we spoke to agreed with us, 100%, 110%, 150%, and more. But most of them then went on to repeat that. Although we were entirely correct in our analysis, such concepts as absolute rights and natural law have little purchase in modern judicial thinking. Even if we got a hearing, the judges would find some way of declaring that these were matters for the government and the people. A nonsense, though a highly plausible one, and yet something that we believed ought at least be put to the test in open court, so the people could be enabled to see into the mechanism of what was happening and about to happen. Even avowedly pro-life lawyers, while agreeing with what we were proposing, seemed to think it fruitless and somewhat absurd to try to challenge these trends. And in fact, I said from the beginning of COVID multiple times that every single lawsuit would be dismissed. And every single lawsuit was dismissed. The lawyers we spoke to all referred to a 1995 case in which the status of natural law had become a central issue. All of them said that in that case, known as blah, 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 the Supreme Court had definitively set out the basis upon which it was allegedly established that natural law no longer had any currency within our legal system. In Canada, our constitution begins with God. This first paragraph of the preamble is a nation under God or something like that. I can't remember the exact words. Literally, if you go to the Supreme Court of Canada and refer to that section, you will be punished with costs. They don't want to hear it. They've written God right out. They've interpreted God right out of it because they don't want it there. I'm sorry, but that's the way it works in positivist, modernist society. Definitely, you want a world of Cicero and Aquinas. Definitely. It is not in doubt that the state, the parliament, and the courts are subject to the Constitution, but the Constitution itself is rooted in natural law. This is Waters' argument. And often you see people untrained in the law become, they really believe that the language means something, and it really is hard to tell them that it doesn't. The rights they think are clear. They're written there. There it is. It says right there, inalienable. It's very hard to explain to people who haven't experienced law from within that is really actually not how the system works. We are in an anti-rule of law society. The bedrock of rights deemed to preexist the existence of every human being, and it is not possible to speak of its contents or logic without recognizing that it's this rootedness in a given schema of understandings and its significance for the contents of the Constitution have been accepted and co-opted by the people in giving themselves their Constitution in the first place. The people, in giving themselves their Constitution, did not in the same action give themselves the right to life. That was already given. In other words, it was antecedent, and being antecedent could not be taken away or surrendered. There can accordingly be no demarcation between the natural law foundations of the Constitution and any of its content. Everything must be interpreted by the light of the premise that the rights and freedoms enumerated and implied within the constitutional text are given to the people and adopted by them in total accordance with their derivation, rather than merely raised up in some administrative, whimsical, or random fashion. This assumption applies especially, though not exclusively, to Articles 40, 44. Beautiful. It sounds absolutely magnificent. And I think what I'm going to be working on is what went wrong and what do we need to do to fix it. The mechanics of this judicial coup, I agree with that language, but it's not just judicial, it's executive, legislative, the universities, the corporations. It's much broader than a judicial coup. Conducted simultaneously against the Holy Trinity, and acknowledging this is a Catholic writer writing in a formerly Catholic country, so all due respect. The mechanics of this judicial coup conducted simultaneously against the Holy Trinity and the legacy of Aristotle are interesting. Essentially, the court adopted what has become a familiar trick of contemporary judiciary establishments, what is called presentism, the technique of redefining words in constitutional text according to their modern meanings, often referred to as the, what's the word for it? It slips my mind. The growing tree concept in American constitutional law. The tree keeps growing, and now it's not a pine, now it's a maple. Okay. All the lawyers observed, again, I love these bits about Waters' encounters with lawyers. They're so informative. All the lawyers observed in a rather vague way that this process had been in train for some time. Yeah, if you were at law school when I was, it was already started. The only thing they seemed absolutely certain of was that they did not wish to mount such a case now. Courts nowadays extended primacy to positive law. They repeated to the will of the people expressed via referendum. No weight was any longer extended to laws that deemed to be given, antecedent, or deriving from anyone or anything higher. Of course, such a proposition renders nonsensical the language of the Irish Constitution, which remained then and remains now the only basis for the authority of the Irish courts. And I would caution you that there is actually an inversion of natural law that you will hear. Many people talk about these higher principles, these absolute principles, kind of anti-natural perversions of laws. So there is kind of this reverse natural law order of ideas and principles that override laws, but for another day. When we got right down to it, it emerged that what they were really saying was that judges just didn't want to hear about natural law. The starkness and absurdity of the situation we had arrived at, several of the lawyers implied, mattered much less than that judges not be placed in the uncomfortable position of having to state in clear terms why words like imprescriptible and antecedent no longer had the meanings given in the most commonplace dictionary. The obvious conclusion then was that there had been a kind of judicial coup d'etat in which the very basis of Irish legal understandings had been altered without consultation or discussion. I'm just going to get to the last concluding thoughts Waters has, and this is the second piece. I'm not even going to refer to the third one. I would invite you to go to it. I invite you to read all three of his articles. They're great. It was difficult reading the courts. This is a referral to a decision he was reading, one that seemed to support natural law, and then one that absolutely, Court of Appeal decision that just gutted it, said no such thing. It was difficult reading the courts, and I think he's referring to the appeal court's lengthy judgment, to suppress the thought that throughout its deliberations and findings, the court was seeking conformity with the government's interests. In this matter, by finding in the state's favor in every single matter of consequence to the rights of the unborn child, and going against the state only when this issue was inconsequential. And he concludes, nothing of the kind could have been affected had the centrality of power of natural law not been fatally undermined, and in effect deleted in advance by a judicial vanguard with a clear view of what it was about, both the vehemence of the language of absoluteness and its persistent repetition throughout what is in effect the Irish Bill of Rights, Articles 40 to 44. And the antecedent pedigree of this code, implicit and explicit, would have presented an insurmountable obstacle to the opaque mission of the various judges involved in these assaults upon freedom and justice in Irish society. What I would say is, no matter what the sources of these fundamental rights, natural law principles, it seems when they're put in a constitution, they become man-made law. They become the law of man. All right, so a few concluding thoughts. So I think Waters highlights the need to rethink concepts like fundamental rights, in quotes, human rights, in quotes, and written constitutions. They're Descartian. There is the isolated individual, the self, and everything else outside is inaccessible except to the experts, to the state. We need these shields called fundamental rights, which really emerge again in the Enlightenment. And we need to put them in our written constitutions. In fact, I think there's a good case to be made that they don't work. Fundamental rights do not protect. And tyranny seems to be running amok since the concept of fundamental rights was recognized and enshrined in constitutions. We need to think a bit harder what natural law is. It's a system in which the individual and the community and, hey, the universe are connected. There's metaphysical knowledge, there's physical knowledge. And we can use practical reasoning, not vast overgeneralizations, but practical reasoning to sort out what's right or wrong. We can do that. People can do that. So what Cicero and Aquinas and Finis are doing is totally different, I think, from what Locke and Rousseau are doing. So on that note, I declare this stream to be ended.
This Parliament dissolved.
Harrison!
Yes, sir.
Move forward.
Right.
Oh, lambent flame. Oh, force divine. Oh, omnivorous power held. None is the swifter to bring destruction. Yet carefree as a child, thou with wild breezes playing. The old Troy shall be no more because of thee, thou harvester that strips the soil for men to sow new crops. Oh, lambent flames. Oh, force divine. Oh, omnivorous power. Hey.